Of course, because the book is there, the whole chapter is there for everyone to read, I slightly adapted what I'll be talking, the topics we'll be discussing today. I just selected 3 sort of challenges stemming from Slovenian labor law, or from the broader perspective from Slovenian social law, because I foremost teach social security law. So 3 challenges stemming from the regulation as such. Of course, first of all, I'll begin with the employment relationship, and Article 4 of the Employment Relationship Act states the elements of a employment relationship, right? Nothing new. The employment relationship is a relationship between the employee and employer, in which the employee voluntarily partakes in organized labor process of the employer and carries out for remuneration continuous work under their instruction and supervision, right? So those are the traditional elements of an employment relationship, which are listed in Article 4 of the ERA. And of course, the legislator and then the courts and also the labor inspection, they have a strong tendency of sticking to the traditional notion of the employment relationship. Put differently, the will of the parties to the agreement is sort of put aside. Where the elements are present, a employment relationship should exist. If the existence of an employment relationship is disputed, that is in front of a court, it is presumed that the latter exists if the elements of an employment relationship are present. And if those elements are present, unless provided otherwise by law, work cannot be carried out on grounds of civil law contracts, also on grounds of contracts that would have been concluded by self-employed persons with their client, well, the employer, right? Of course, different ways of bypassing the law. It is very common practice in Slovenia, in certain professions, workers actually carry out work as, well, employees carry out work as self-employed persons, right? In some sectors, it's to their greatest benefits because they can increase their net income that they earn, right? In some professions, they're bullied into the status by their disguised employers, right? So today I will shortly discuss a very, very common practice that is in a way beneficial for all, and it applies to high earners, so tech professionals, lawyers, etc. They conclude an employment contract with their employer for a minimum salary only. Then they register as a afternoon self-employed person. That is a special institute that allows persons who are fully employed via an employment contract also to carry out business activities on their own as self-employed persons. I also do that. I do consulting, right? But I'm fully employed for more than a minimum salary at the university, of course. So what they do, they conclude that contract of employment, pay out a minimum salary, and everything else is just bypassed through their self-employment status. Why? Because they pay very, very, very little social security benefits and very, very little taxes off of that income. It's fixed social security benefits, and only 20% of income, only 20% of the whole revenue is taxed, and it's only taxed 20%. So that is very, very common practice. In Slovenia, that applies to high earners, lawyers, tax specialists, etc. And of course, there is no conflict of interest there, so there is no disputes present. Or put forward, of course, in front of the courts and also the labor inspection. I think it doesn't poke into those cases too much. All right, now because we were discussing when we were reviewing the book, this sort of popped up as an interesting topic, and that is the economically dependent person. Now, who is that? Is a self-employed person who, on grounds of civil law contracts, personally for remuneration, independently, and on a long-term basis carries out work in the circumstances of economic dependency, meaning that 80% of annual revenue is provided by the same client. That is basically a self-employed person working with one client only, or at least 80% of his annual revenue is obtained through the venture he or she has they have with one single client. And they also don't employ other workers. In such cases, limited labor protection applies, and it relates to the prohibition of discrimination, minimum notice periods, particular reasons under which the contract relationship can be terminated, collectively guaranteed rates of pay, and damage liability. Does it work in practice? No, absolutely it doesn't, because basically no self-employed persons declare themselves as economically dependent, self-employed persons as economically dependent persons to their main client, because suddenly, of course, well, the client might think of himself, or well, themselves as a employer and cut the business relationship straight away, right? So we have very, very low numbers. I didn't look into the statistics. I should have done that. Very low numbers of self-employed persons who actually declare their economic dependency and would thus obtain a higher level of labor protection, or at least minimum labor law protection that doesn't apply, of course, to traditional self-employed persons. So that is the second topic I wanted to discuss briefly with you today. And the third one is my favorite one because, well, letting go of the old. It is an amendment to the Employment Relationships Act and the Public Employees Act. It was from 2020, or it could have been 2021. It doesn't really matter. The Parliament amended the provision of both pieces of legislation as to allow for the termination of employment contracts of employees who fulfilled old age retirement criteria, not without a business reason present, but without having to substantiate a business reason, to explain the reason, which to me just seems ridiculous. What was the government's argumentation for the change? Well, there still has to be a business reason present, but we will, in times of COVID, we will let the administrative burden slide. So the reason has to be there. Only the employers don't have to sort of back it up, don't have to explain it. Another reason was, if we let go of the old, meaning elderly workers, employees will facilitate the employment of junior workers, which again doesn't make sense at all, because if there's a business reason present, how can you let go of one worker and then substitute them with a new junior worker, right? And of course, also this substitution wasn't made mandatory. Anyhow, I was waiting for the decision of the Constitutional Court. Once I read it, I was a bit triggered. First and foremost, because I wasn't cited in it, and I did write something on the topic. And then because the court, actually, we were all waiting for the decision. Private autonomy, non-discrimination, equal treatment, etc., right? The court didn't go into those topics, those questions at all. They just looked at the international legal order, the ILO Convention 158, which requires a valid reason for termination. They looked into the European Social Charter, which also requires a valid reason, and they just said, well, the amendment to the both pieces of legislation is not in line with international legal order, thus it violates the constitutional principle of legality. That was that. No talk on equal treatment. They didn't go into the substance of the case. They solved it correctly, I think, but no substance is there apart from the principle of legality. Wait, that's that. Yeah, that's that. Well, I didn't want to go into the things that are covered in the book. Everyone can read that. So I've selected 3 things that I consider to be interested. That is very interested now. It is very current. The economically dependent person is something that is sort of linked to. I haven't seen that institution in other legal orders. Correct me if I'm wrong, but it relates to our legal order the most, I think. And bogus self-employed persons, that is an ongoing topic, I think, in all national orders. I just wanted to give I think the most interesting example of how to bypass the said legislation to avoid paying taxes and social security contributions, but of course not in order to give out any good practices, just to show how bad practices can come up easily if the legislation is not thought through enough. All right, thank you very much for your attention. And the questions now or later? Later. All right, I'll be here, of course.
Thank you. Good morning, everyone. It's a pleasure to be here, and I'm very glad to be able to look over Luka's paper on Slovenia's labor law. And I would start my presentation where Luka dropped off the ball. And what struck me most in this paper is to see how quickly and thoughtfully learn governments from each other. We usually discuss what is the interplay between different jurisdictions and different courts, like the European Court of Human Rights or the Court of the Justice of the European Union, learn from each other and reflect each other's case law. But it was very interesting to see how fast governments can learn from examples, whether for good or bad, that's up to you to decide. So first, Luka's paper starts off with a very interesting notion on how, under the auspices of emergency legislation triggered by the COVID-19 pandemic, allowed governments to adopt pieces of legal measures, decrees, whatever, which were not strictly related to fight the pandemic. Wow, I think we can organize a separate conference on that concerning the Hungarian legislation. Second is what was very interesting for me is to see that despite the very different economic backgrounds of Slovenia and Hungary, speaking of political economy and the cluster series, I mean, despite of the shared post-socialist state socialist past, Slovenia and Hungary dropped off very differently after 1990. Slovenia became one of the flagship countries of neo-corporatist development, whereas Hungary is rather a market-dependent economy. And for me, that at least as a black letter of the law would mean that, for example, the approach of governments towards social dialogue or social partners must have been very different, because that is what political economy is saying. However, I was very surprised to read that the Slovenian government neglects its responsibility to discuss economic and social measures with social partners, and that the tripartite social dialogue is dragging, and this economic and social council is not functioning as it's supposed to be, at least according to trade union representatives. Now, that's something, again, which shows many similarities with the Hungarian practice or actual situation. Now, talking about the other kind of similarities between the two legal systems, I found it very interesting, and I must say that it's not so evident from the paper or from the chapter what is the court's practice on distinguishing between employment contracts and other labor relationships, because from reading the chapter, I saw that, that's great. So the Slovenian courts uses a mixed test based on factual things, and also looking at the economic risk of the workers. And I said that this is great, and so forward-looking and stuff like that. Especially that like 2 weeks ago, I was on a conference when we have to explain to judges coming from different jurisdictions, like how the Hungarian jury is deciding whether something is a labor relationship or not. And we demonstrated that we have this ministerial decree from the 1990s describing the major qualification areas, and it's not yet enforced anymore, but it's still much relied on by courts. And one of the commentators from ILO was saying that, okay, so if I want to sum it up, you don't have independent labor courts anymore, and judges relying on a piece of legislation which is not enforced anymore. Is that right? It's like, yeah, it is technically correct. This is the situation. So I thought that it's very good that the Slovenian court is doing something much more forward-looking thing, but based on the presentation, I just realized that it's not operationalized in practice. However, I think one of the most important challenges of labor courts and actually legislators as well to fight against bogus employment and see how people working under precarious contract can be protected under the umbrella of labor law. I think so that this is an area which we should pay the most attention. Now, concerning the differences, first, I start with the last thing Luka mentioned, is the dismissal of people who are already reaching the age of old age retirement pensions. Well, we had this kind of discussion with the Strasbourg court like 10 years ago, so maybe I can show you the decision of the court scrutinizing why it's not violating the European Charter of not the social charter, but the European, how does it called, Human Rights Charter, because those who retired already have the benefit from the pension fund, so the meaning of living is not completely deprived of. So they are still protected by the state, so that's not necessary to continue the employment relationship. That's a very interesting case, so maybe I just discuss it one with you. Now, what was also very interesting for me, going back a bit to the fight against bogus employment, is that the similarities of sanctions of the labor inspectorate and how it was renewed in the past. So I think labor inspectorates or should have an important role in that fight against precarious labor relationships. Now, what again is very different from Hungarian solutions is, and actually I laughed out loud when I read that those employers who are not willing to reinstate people for their job if the court ordered so, due to several reasons, are facing criminal sanctions of imprisonment up to 1 year. I think that's fabulous. I mean, really, that is a deterring sanction, as it said so by the European directives. And last but not least, and again it goes back to the different economic setups of the two countries, I saw that how Slovenia's economic interest is different from that of Hungary relating to posting and the newly implemented, or should have been implemented, directive of the posting of workers, and what are the different economic interests related to the Slovenian resident frontier workers, because that one in Hungary is not really present. So I think that these were the most important differences between the two systems I could come up with. And last but not least, I think that it should be just the beginning of a wonderful friendship, and I really hope that we can continue discussing these interesting labor issues, especially with regard to the upcoming implementation of the work-life balance directive, which I think again would be a very interesting area to compare how the national legislators solve this problem. So I really look forward to more events to come in this field and to continue this fruitful discussion on the interplay of different legal systems. So thank you very much for having me, and I wish you good luck for the future. Thank you.